motion of desirability for the bill to, no, the motion of desirability will be on the IEC amendment, because we have dealt with the motion of desirability on the private members bill by Honorable Carter. We'll then have to deal with the electoral amendment bill, which was presented both by government, and we have had the IEC to come and engage with the committee. And I think where we are sitting, we are at the level of dealing with the motion of desirability now for the bill to be then a process for public comments, but at the same time looking at how do we collaborate and work together with the second house, the NCOP. In the last meeting of Chair of Chairs, I did raise a concern that this is one of the agent bills that is before Parliament, because it gives a rise to the operations of the IEC. So therefore, it's one of the most important bills that is before Parliament, that Parliament must process, so that the IEC has enough time to prepare for the elections, the coming national elections. So on those bases, therefore, we'll only deal with the two items. The other items, between the Department, Minister of Home Affairs, and the Fireblade, that item will come immediately after the House adjourn at 4:30. So we'll expect the department, together with the Minister, to be in the committee at 4:30 to deal with the issue of the Fireblade. I think in that regard, all of us are aware that the committee has done its oversight via having started to interact with the Minister and the department, and we've received a number of briefings by the department on the Fireblade. We then know, and we invited the Minister to deal with the Fireblade after the appeals, and the matter was then agreed that he's going to be appealing at the Constitutional Court. And I think then the decision of the committee was very clear that we'll support the Minister on the basis of what we have learned, based on what you told the Portfolio Committee, that will then support the Minister to go to the Constitutional Court. And where we are sitting, I think we now know that that application has been dismissed. So we'll deal with those matters later. I don't want to preempt the outcome or to get the engagement of that meeting, but we'll deal with those matters later at 4:30. I think now the committee's operation, by now where you are all seated, we now know that we can go beyond. Even if we were to do it until the following day at 6 o'clock in the morning, it's still fine, because we're here to service the people. When you are employed at Home Affairs, you're told you're coming to serve the people. So there's nothing to rush. In fact, that's the approach that we're taking. We're not going to rush. We have to work and get to the detail of every single little thing, so that by the time we report to the National Assembly, as mandated by the Constitution, we give thorough reports that are clear, clearly understood, well thought, well oversight over those reports and all of that. This is the approach that we are taking. So you're going to bear with us. I know that you are used to be this quick thing, that you come to the committee, present quickly and with a lot of acronyms and all of that, and then disappear. It's not going to happen anymore until such time that we have another new chairperson at some point after elections next year. For now, we're going to work in that particular approach, right? Now we'll then deal with the issue of the Fireblade. We requested the department to give us a list of litigations. And the last time we received a document from the department on litigations, they're going to speak on that. The reason that we have done that is because you have, where we are sitting now, in the public domain, is known that there's a company that is suing the department for 740 or 750 million. And you must know that all those litigations is public money that is spent, right? And at the same time is that this Committee of Parliament has a responsibility to do oversight over anything that you do in that department. So we requested you to submit the report, and the report was submitted. We could not even read that report. The font was so small, and someone was doing it, was just doing it for compliance. I just want to put it very clear that it's not acceptable. Even yourself who submitted this report, you know it, you could not even read it yourself. It's not acceptable to submit such information to Parliament, you know, because we are really disenfranchising members of Parliament to understand exactly what are the issues. Then the report then was sent back. We took a decision as a committee to send it back and get a proper submission. The proper submission came, but does not have the content as the previous submission that was. You know, where I'm sitting, I know of cases that dates back some 15 years ago when I used to chair Home Affairs. And those cases are still before Home Affairs. I know of such, right? And I think the information that has been submitted here is not fair. That you then decide to package what you think is right for the committee to hear or to know. The rest of the issues, you have kept them under the carpet. But we'll deal with that when we come to that process. Just relax. I did engage with the DG on the last item, and both, not myself, the Speaker of Parliament, did write to both, I think, the Minister and the DG somehow, with regard to the incident that happened at OR Tambo International Airport on the members of a SADC Parliamentary Forum, the incident that happened there. So we're going to get a briefing because I did speak to the acting DG. We wrote formally that this matter must be investigated, and we expect the report to Parliament so that we are able to process it correctly, and whatever the outcome it is will be guided by yourself based on the investigation that you have done. So those are the issues that are meant for the committee. Well, I've just been made aware. The last one is a VFS arrangement. You are the company that is not the last one. It's item number 6. Sorry, item number 6, which deals with the issue of the visas. Where we are sitting, we are aware that that contract is expiring in December, and we told you earlier that we know your intention is not to advertise. Your intention is to proceed to give the VSF that opportunity again. And that's what I received so far from the department, that no, in fact, we are proceeding with that. We'll deal with that issues, but I think we'll have to talk more about that area at some point. The committee has taken a position on that. In our BRRR report, we have made it very clear that we took a resolution on this matter. So we'll deal with it when the item comes before the committee later in the afternoon. So on that note, therefore, colleagues, let me allow the committee section to check if we have any apology in the meeting. The secretary will take us through any apology. And then a content advisor will then start with the engagement around the civil union and those submissions that we have received. He has prepared them. Yeah, on that note, let me welcome you, DG, Acting DG. Mavuso, you're welcome. The Acting DG was JM, Jackie McKay. I see in the legal documents they refer you as JM. So I'm going to be calling you JM now. Yeah, Finland, I see that you have raised your hand. Did you raise your hand?
Yes, Chairperson, good morning.
Yes.
Anif is on his way.
Anif is
stuck
on
in
his
a traffic, yes.
Okay, that's fine. Thank you very much. Any other apology, Eddie? Take us through apologies.
Good morning. There's no other apology that I have received.
It's only Anif. We have a full house today. No, thank you very much for the attendance. And welcome, Honorable Carter. And we really appreciate the work that you are pushing there. Can we therefore start with the presentation of the amendment as you have received them? Bearing in mind that both the Department of Home Affairs, the Parliamentary Legal Services, they've been doing work around this particular piece of legislation. And then having gone through now, the public submission will then deal with the way forward as to how we then process this piece of legislation. Okay, thank you very much.
Good morning, honorable members. So in total, firstly, we have 2 documents that I've submitted, which are summaries of all the submissions. They're titled very small on the top, submissions against and submissions in support. So in total, there were 568 submissions. A lot of them were duplicates, so essentially just different people signing on to the same submission. What I've attempted to do is summarize it a little bit. It hasn't been hugely summarized, just because we haven't had a lot of time to go through all the lots of submissions. However, it will give a broad overview. I'll try to highlight some of the key issues in the presentations that are here. So just generally overviewing, we have, of the 568 submissions, 65 were against the Civil Union Bill amendments, and there were 503 in support. I'm going to start with the submissions against, just because there's less of them. And then we'll move on to those in support. So what you'll see there on the submissions against Civil Union Bill, which is a...
Document we are referring to, just guide members.
Yeah, there are two documents. The top of the document will say submissions in favor or submissions against. So I'm going to start with the submissions against, which is the shorter of the 2 documents. So we've got the submissions numbered on the left-hand side there, so you can see the total number of submissions. However, the first submission was signed by 33 individuals or organizations in support of this. And it's not a clear distinction as to which groups are bigger or larger. Each organization that submitted attested to have however many members, which we haven't verified. So it's not a question of the equal, like merely just the number of submissions. There are different numbers of people supporting each of the submissions according to that organization's size, which I give here some indication in those organizations where they, in their submissions, indicate what the size of their congregation is, for instance, just because that's something that they highlighted in their submissions that were different from the main submission. Essentially, the 2 main arguments which members will already be familiar with are essentially the right to religious freedom and the right to equality, and these 2 competing interests are largely define the 2 groups, either in favor or in against the submission. So without going through the full content of all the submissions, what I will highlight for the first submission is essentially that these mostly church organizations and church congregants highlight that the bill would violate the constitutional right to religious freedom and dignity of state-employed officials, because their religious convictions and beliefs, they do not see to be able to support solemnization of same-sex marriages, but would be forced to do so or suffer the consequences. The submission submits that there are viable alternatives to amending the bill, rather, and essentially what they're proposing is that there be roving Home Affairs officials that go to all the areas where there are less available marriage officers to solemnize civil unions, such that to address the shortage of such services in more rural areas particularly. So this is a common theme across all the submissions against. And what they also indicate is that the religious rights or religious mentalities of those officials who conscientiously object, that they do not leave these at home when they go to join the office or join public life, and that this is in fact supported by the Constitution, Section 36, which indicates that there should not be any unnecessary limitation of rights, and that limitations should be reasonable and justifiable, taking into account amongst other things, less restrictive means to achieve the same purpose. So where the judicial officers who go to rural areas ensure to, so essentially they're saying that a less restrictive way of addressing the shortfall of civil union marriage officers is to rather have roaming home affairs officials rather than have to change the legislation. The second submission there is actually from somebody who's against the Civil Union Bill completely. They're saying that there should rather be an amendment of the Marriages Act completely and that there shouldn't be separate but equal legislation. So this is actually somebody who's in favor of same-sex marriage and saying that the Civil Union Bill is like a remnant of the apartheid era where there was separate legislation for some people versus others. So this is an interesting case of somewhere coming between for and against. So then, largely going through the submission 3, submission 4, going up to 7 are essentially all just religious objections on the basis of the violation of religious freedom and dignity. The section submission 8 there is interesting for somebody who indicates that they were formerly homosexual and now object to the suppression of Muslim, Christian, or Hindu faiths as proposed in the bill. Section 9, submission 9 is also just a general religious objection with no significant new additions, other than that they, in point 7 of that submission 9, indicate that most religions, African traditional, Judaism, Islam, Hinduism, teach for the need for heterosexual marriage and the procreation of children, and the stigma attached to not producing children through marriage is ingrained in all these faiths. And saying that discrimination or to dismiss a state official or marriage officer on the basis of his beliefs against same-sex marriage is unnatural and also transgresses Clause 22 of the Constitution, in which every citizen has the right to choose their occupation freely. That's point 8. So then submission 10, so I'm not going to go through all the submissions, I'm just highlighting some pertinent facts, pertinent issues. This submission indicates that marriage was initiated by God himself and that the bill comes to destroy the whole of family and society, for children to be raised in a home where there is no mother or father. Then 11, 12, 13, essentially the same, based on Christian belief. 13, there I'd just like to highlight that they highlight aspects of the court ruling of the Minister of Home Affairs versus Fourie in 2005, where Judge Sachs implicitly stated that the conscience of state employed marriages officers should be protected. So that ruling does in fact mention that. Then 14, 15, the same, and then just something to highlight on 15 there, the last paragraph. No one should have to choose between obeying their faith and potentially suffering eternal consequences if they do not, or obeying the law and potentially losing their jobs if they do not. And it would be unconscionable for the state to place employees before such a choice. 16, 17, 18, 19, essentially the same. The Cause for Justice, submission 19, it's human rights promoting a public organization, which was an amicus curiae, or like a friend of the court in several cases relating to religious rights, in particular in schools. And something I'd like to highlight on that is point 18, which is on page 6 of that submission. Highlights that irrespective of the true extent of the issue, the lack of service delivery to same-sex couples, the DHA is able to deliver services at 28% of its offices in answer to the need of less than 1%. So the statistics they provide indicate that less than 1% of marriages are conducted by, are provided to same-sex couples or non-heteronormative couples. And that of the staff contingent of 1,100 marriage officers, 62% are willing to register same-sex unions. In answer to that, less than 1%. So essentially they're saying that the DHA has an oversupply of marriages officers who are willing to register the same-sex marriages, and essentially that the problem is not the bill or the act, but rather the logistical planning of the DHA, and that they should essentially just address this by better planning and reallocating people to places where there are shortfalls. And also, they then indicate on point 29, which is on page 7 of the submission, of the summary of the submissions, that they indicate that it might be possible that some of the people who object to solemnizing same-sex marriages are in fact bigots, but there are also sincere conscious objectors, and it must be accepted that marriage officers who are conscientious objectors are not motivated by a desire to prejudice or harass others on the basis of their sexual orientation, but rather to live in accordance with their sincerely held beliefs. The point 30 on that submission also indicates that the Bill of Rights may be limited in terms of law of general application, but that the limitation needs to be reasonable and justifiable in an equal democratic society. And the limitation of rights entails a balancing exercise, which is the purpose to maximize promotion, protection, and enjoyment of rights of all persons. Therefore, at least in the least restrictive manner, to limit the rights is to be preferred, and this again in support of roving Home Affairs officers. Then I'll skip forward to point 47 of that submission, which is on page 9. It's indicating that 267 out of the 382 Home Affairs officials objecting to solemnizing civil unions indicated that there are a significant amount of people living in accordance with their religious beliefs, and that the location of where these Home Affairs officers are, being rural Limpopo, Mpumalanga, KwaZulu-Natal, and Eastern Cape, also suggests that cultural beliefs regarding marriage, family, and intimate partnership relationships are important to many marriage officers. And then point 48 there, unfairness of the discrimination does not reside in granting of a right to conscientious objection to marriage officers. Rather, the cause of unfair discrimination is geographic and budgetary in nature, following from a lack of proper planning by the public authority. Then on page 10, point 51 there indicates that South Africa is not a secular state. Constitution welcomes religion in the public sphere. The state is obliged to reasonably accommodate the existence of freedom of conscience, religion, and belief of marriage officers who object to solemnizing same-sex civil unions. I'm going to skip down to point 57 there, which is essentially just the geographic point again, that essentially it's just a bad distribution and planning on the count of the DHA and not prima facie discrimination. Going forward to point 65 on page 11, part of their suggestion there is that the DHA publish a schedule of days in which roaming marriage officers can attend to specific Home Affairs officers, and may provide mechanisms where same-sex couples can make a special request for a roving marriage officer to attend a specific Home Affairs officer at an earlier date. Although it's possible that same-sex couples might experience very slight delays in service delivery, they will be able to solemnize their civil unions at Home Affairs office of their choice and would not be deprived of their constitutional rights. And then going on to point 67 on the conclusion there, the Constitution requires that rights be balanced in a manner that is fair and maximizes the enjoyment of the rights of all persons. In order to achieve this, the relatively practical and simple solution is providing roving marriage officers. And that this balances potentially conflicting rights of the same-sex couples and marriage officers. Same-sex couples would be able to exercise their right and have their civil union solemnized, while the right to conscientious objection of marriage officers will still be preserved and not permanently extinguished. Okay, so that's just aspects of that submission, with the references to various international research, then more various research supporting it. Then I'll go on to submission 21, which is Freedom of Religion South Africa, again, religious and rights-based organization. There I'd like to highlight point 10 on the page 12, which indicates that the inclusion of section 6 in the Civil Union Bill was not a legal blunder, as has been argued by some, but that the conscious objection clause was specifically written into the Act by Parliament following the recommendation of the Constitutional Court in the Minister versus Fourie, on the principle that reasonable accommodation could be applied by the state to ensure that civil marriage officers who had sincere religious objections to officiating at same-sex marriage would not themselves be obliged to do so if this resulted in a violation of their conscience. Okay, they also proposed the roving marriage officers solution to address this. And on page 13, Roman numeral 7, there indicates that it is submitted that having a dedicated state-employed marriage officer who can assist same-sex couples having their union solemnized may even result in them having their union solemnized much quicker than in the case of many heterosexual couples who have to patiently wait their turn. And they're also indicating on point B there point C there under the assignment of employees to specific officers on Roman numeral 2 that an affirmative action-based approach could be used to address this issue, that rather than dismissing Home Affairs officials who are not willing to comply with same-sex solemnization, they should rather be progressively replaced by Home Affairs officials who are willing to do such unions, and thereby slowly but surely eradicate the discrimination. So then I'm going to move on to submission 24, which indicates that in the third paragraph there, that the right to freedom of belief and the right to human dignity cannot be separated. And in relation to a Justice Sachs ruling, the right to believe or not to believe, and to act or not act according to one's beliefs or non-beliefs is one of the key ingredients of a person's dignity. So just arguing in favor of dignity and religion being related. Then 25, 26, all the same, essentially, and then going to submission 30, which is from a combination of the Evangelical Alliances of South Africa, which claims to represent 4 million evangelical Christians in South Africa, and the Marriage Alliance of South Africa, which is a Christian association supporting the protection of the institution of marriage, which claims to represent 20 million South Africans, Christians. And they were amicus curiae, also a friend of the court in the Minister of Home Affairs versus Fourie Court, which eventually led to the Civil Union Bill, or Civil Union Act. What I'd like to highlight there is submission, or point 2.1 there on page 15, which indicates that the tens of thousands of submissions were made to the portfolio committee in 2006. respecting the Civil Union Act was thoroughly considered by Parliament before it was enacted. Sections 5 and 6 were the product of an outcome of many submissions by people of faith. And a simple removal of Section 6 without further public hearings in all provinces will fly in the face of the public participation in 2006. 2.2, I'd like to highlight there just aspects of the Fourie court ruling was that LGBTI groups on the one hand and religious communities on the other, there's the balancing act that needs to be conducted between them. And the judgment notes that both contesting groups are citizens of South Africa who are entitled to be protected by the Constitution. More importantly, the judgment calls for legally justifiable sharing of the common space, which is the public sphere. In an open and democratic society, contemplated by the Constitution, there must be mutually respectful coexistence between the secular and the sacred. The function of the court is to recognize the sphere which each inhabits, and not to force one onto the other. Then I'd like to just look at the last paragraph on that page 15. The Constitution between the sacred and the secular, the fact that the open and democratic society contemplated by the Constitution, although the rights of non-believers and minority faiths must be fully respected, the religious beliefs held by the great majority of South Africans must be taken seriously. As this court pointed out, Christian education, freedom of religion goes beyond protecting the inviolability of the individual conscience. For many believers, their relationship with God or creation is central to their activities. Concerns their capacity to relate in an intensely meaningful fashion to their sense of selves, their community, and the universe. For millions in all walks of life, religion provides the support and nurture and a framework for individual and social stability and growth. Religious beliefs has the capacity to awaken concepts of self-worth and human dignity, which form the cornerstone of human rights. I then go to the next page on point 2.3 there, that being compelled to solemnize same-sex marriages was not part of the terms and conditions of employment. By unilaterally changing the terms of employment, the state employer would be committing unfair labor practice and open up the state as the employer to a deluge of litigation at the cost of the taxpayer. Then 32, 33, essentially the same arguments as the above. So that's just in brief overview the arguments against. More specific details obviously included. It shouldn't take too long to read through the summary of these submissions. So I'm going to then move on to the submissions in favor.
Do you want us maybe to deal with against first before you move to favor, so that we can then strike the balance, that we are not confused in between, because they're quite very detailed submissions with regard to against. I mean, both of them, they're very detailed. So if we were to opt for taking both of them at the go, we may end up either missing the point. I'm not sure. Our colleagues will advise, but I thought that maybe we can open for a brief discussion around. Colleagues will have noted some of the objections that came in. And again, Honorable Carter, I think you have had an opportunity again to look at the submissions. Did you have enough time?
Not necessarily.
You did not have enough time to look at
I don't think they would have gotten all of them,
at the
but we
objection.
received everything.
And for members, again, we have just received these submissions now. But I think the one is on members again. I mean, if you wanted to comment on the submissions, especially because we have now categorized them to be those against and those in favor.
So if I may suggest with respect, just given that we want to finish in quarter to 11, I might not be able to finish in favor. So to give an overview, and then have members
when
consider
the
the
chair
actual
is
substance
one,
by reading it, just with respect.
No, but mostly you're presenting, I'm testing the members' view. It's not for you to want to suggest. Please, I understand that. Because members, I want a guide from them. No, relax. Adam, I'm running the meeting. Not run the meeting, I run the meeting. Okay, relax, you have a responsibility there. We're not going to do the rush. That's why I said to you earlier that whatever that we do must be thorough and very detailed. You receive submissions, people spend time. They spend time to look at what we have sent to them in the public space there. And then they then comment. And when they comment, they raise a number of critical areas that require attention. And for us to have a bill that will pass the constitutional muster is very important. Of whatever that we do, it must be clear, balanced, and clearly understood. So on those bases, I wanted to solicit the views of the members. Honorable Waters.
Chair, given the time constraints, let's hear both sides. It gives us both pictures, for and against, and then from there we can deliberate. Thanks.
Mama Raputi. Mama Dambuza itibokunikeza amanzi ashisayo. Angifuni ukolapse namhlanje. Sisi fakela uMama Dambuza amanzi awom nelemon laphana. Because akaphilanga kahle. Angisafuni bantu abawayo kule committee this time around. Honey, if there's honey, please just get a honey too. Okay. Okay, Mama Dambuza. Mama Raputi.
Yes, seeing that we have just received this documents, can we be given time to go and also interrogate them properly?
Okay.
Yes, because we cannot be in the rush
Okay. Now
situation.
Okay.
Thank
Listen,
you.
what we'll then do is that we'll then, I think we'll then proceed and present the next submissions, right, which are 4. And then we can then have some brief discussion, but then means that allow members time again to engage on such. So that in the next round when we meet, we then meet with going deeper into the amendment themselves now. I think the parliamentary advisor will guide us again on how therefore do we sort of, because they come raw as they are now, but what is key that is coming out of the submissions can be extracted in both sides of against and those for, and then look at those issues that are coming out. Without really forgetting that the constitutional requirement is that the state may not discriminate on sexual orientation. That's a fundamental line that we must never miss as we proceed, because that gives birth because that particular line gave birth to what we now call the civil union. So I think that's how we should approach it in that line. It still calls us back into that 2007, Minister Malusi, when we were still dealing with the civil union engagement, and those experiences are back again. But that line is a line that guides us in anything that we do. So on that note, let's allow Adam to then proceed. Comrade Gumede, you right? Let me give
Yes.
Gumede, you'll come, Adam.
No, it's correct. I fully agree, Chairperson. But I just wanted to check whether representatives of workers from Home Affairs, have they put across a view? Thank you.
Okay.
Yes, both in terms of individual submissions from marriages officers themselves, which are indicated in the against submission. I think there were 3 submissions from marriage officers themselves, indicating their personal objections to being forced to do these marriages. But then also COSATU, which represents the biggest workers' union in the country, make a submission in support of the bill, saying that non-discrimination is part of the Constitution. So there are aspects of both from both parties, from support on either side.
Okay. Adam can then proceed.
Okay, so
let's receive the second document. I think we have noted the first document, And then let's receive members in position of the second document.
Yeah, it's a submission in favor of civil union bill, titled at the top of each page.
Thank you.
It's about 36 pages long. So slightly longer and more detailed than the initial submission or the initial summary. So what we have there is there are three main submissions which got significant co-signatories to them. So if you look at the first three submissions, what we have there is 64 signatories to the submission 1. And then on page 2, there's 139 signatories in support of submission 2. And then submission 3, there's 230 signed hard copies of submission 3. So we didn't have time to go through, write down the individual names of those persons, but they're available should members require them. So everywhere else I've mentioned the name of the actual submission persons or organizations. Just that one we haven't gone through the individual names, but there are 230 signed copies submitted in support of a free gender submission. So then going just to highlights again of all the submissions. In submission 1, the point sub 6 there, I think members are already familiar with Honourable Carter's arguments in general, so I'm not going to go through them in a coherent order, but rather just highlight some of the pertinent aspects. So point 6 on page 1 there is that state officials have a fundamental right to believe whatever they like, but public servants should not be able to pick and choose which laws they will follow and which services they will provide. 7, we are sympathetic to the potential labor implications following the possible repeal of Section 6, in that staff might reasonably object to conditions of service being changed. However, there is no impediment to any new job applicants being asked to affirm that they will indeed provide the same services to citizens in the future. Then going on to page 2, with the 139 signatories. The second paragraph there is that Section 6 allows for prejudice against same-sex couples by marriage officers by giving those officials grounds to object solemnizing such unions. No such allowance is made for any other factor, bar for sexual orientation. So nothing on gender, nothing on religious orientation or a cultural group or race. It's only sexual orientation. So this is the one exception to the otherwise non-discriminatory legislative regime. And then the 230 signed copies on submission 3, so the biggest supported submission by and large, has three main arguments, essentially on the importance of equality. On page 3, you'll see the arguments in favor of equality, B, in favor addressing issues of religion, and C, the balance between religion versus prejudice and homophobia. So what I'd like to highlight there is under A.7, the last two sentences of that point is that this may mean that same-sex couples have to travel to more than one office before they can get married. Same-sex couples that are poor cannot afford to travel to different offices. Section 6 could prevent poorer same-sex couples from getting married. Then on the point of religion, the Constitutional Court that it would be out of order to allow religious beliefs and values of some to guide the constitutional rights of others. The state is separate from individuals' personal religious beliefs, and individual personal beliefs should not determine who receives services from government. And then point 10, under religion versus homophobia, the point indicating that there's no way of knowing for sure if the officer refusing to marry same-sex couples really holds the religious beliefs or simply does not like LGBTI persons. And in conclusion there, point 13, in solidarity with promoting equality and dignity for LGBTI persons and everyone's right to marry, they therefore make the submission. Submission 4, what I'd like to highlight is the last sentence there on page 3. 84 of these submissions indicated their support of the repeal of Section 6 of the Civil Union Act. Of these submissions, and only 17 of these submissions did not support the bill. So this was in relation to the draft bill submitted by Honorable Carter. Then on page 4, what I'd like to highlight there is under point 5, there by this Free Gender organization, which made both their own submission and also kind of piloted the most supported submission that they've done, that the Legal Resource Center has done extensive research and made a report on such matters that members can refer to should they wish to. Point 6 there.
I just want to do some small intervention. That maybe what we should do, members, is that this document then get tabled to the committee as prepared. And then we move to the electoral amendment. The reason that I'm trying to push the issue of time for the electoral amendment, the civil union, I know it is urgent, but the electoral amendment becomes very, very urgent. Already work has been done there. At the level of the electoral amendment is to push for the motion of desirability, having dealt with the rest of the issues that we have received. So I thought we should pause here on the submission. We'll still further proceed with that because the issues that are raised at the second document are in line with what Comrade Carter has proposed generally. So that's what I wanted to propose, colleagues, that because I'm looking at, we're now at 20 past, say, 10. We left with 30 minutes. Or unless we do 10 minutes and then we come back, we do the remaining 30 minutes. But we said we want to adjourn before 11 o'clock so that the venue can then be prepared for the engagement of the next meeting. So I wanted just to, because members said that we just received the document, maybe we'll have enough time on our own to go through the document again. There's nothing wrong to do that. Then we can then begin to prioritize what must be done, because I want from here, having agreed on the issues of the electoral amendment, there are processes that need to be engaged on, that we have to deal with. Are you fine with that? Yeah. What you call Hossein, I see you raise your hand. Yes.
Chair, I don't mind your proposal. I just want to ask, how much longer do you think it will take for us to just conclude what we're doing at the moment?
No, it's quite a very thick document, by the way. You have, it says we'll do it in 15 minutes, then we'll only have 10 minutes to do the electoral amendment. Why do we have to rush ourselves to that extent? Let's hold it here. We'll then proceed with the process later. I mean, by later it means that you may, unless we want us to proceed and close this matter, and then later still go back to the electoral amendment. If colleagues are saying that, then it's fine.
Chairman, I suggest that we just try and, just conclude with what we have to do as quickly as possible. If that's not possible, then we're going to have to come back. But
let's do this. Let's allow Adam to present and finish the whole document. We'll be left with 10 minutes. When we started the meeting later today, we're going to start with the electoral amendment. For another, and we must know that we have invited the minister to come later. I've not consulted to check with him any other engagement after here, because there must be consultation. We'll have to ascertain that. Failure to which the committee will finish very late again. We'll finish at 6 o'clock or 5 o'clock the following day. I don't have a problem with that, man, because I'm trying to make things easy for members. Let's proceed, Adam. But bear in mind that the later meeting may not be possible, because we have not checked with the minister if he's going to be available after that engagement we're going to have with him. Proceed, Adam.
Thank you, sir. So then on page 4, just making reference there to, there's a link to a document with extensive research in support of this organization, which is Free Gender. Free Gender is primarily black lesbian organization based in Khayelitsha. What I'd like to highlight in their submission is point 13 there, that it's unjustifiable, a violation of the rights to equal protection under the law and under Section 9.1, and to not be discriminated unfairly in terms of Section 9.3 of the Constitution. And also indicating, just based on their experience, but also just historically, there is a legacy of severe historic prejudice against same-sex couples, which requires specific intervention and in terms of also protecting their constitutional rights. Point 15 there, affording same-sex couples the right to marry does not in any way lessen the capacity of heterosexuals to marry. So there's not a contradiction in those two. Point 16 there, that the court found that providing same-sex couples the opportunity to marry in the same way as done for heterosexual couples was not allowing such was a violation of their right to dignity in terms of Section 10 of the Constitution. And then moving on to page 5, I'd like to look at point 20 there, the second sentence, where the rights and obligations associated with marriage are vast and include the duty of support, the right to inheritance, medical insurance coverage and adoption, access to wrongful death claims, spousal benefits and bereavement leave, amongst others. And that the court found that the need for affirmation and protection of their intimate relations as human beings is somehow less than that of heterosexual couples if they don't have equal access to such services. This exclusion further signifies that the capacity for love by lesbian and gay persons, commitment and accepting responsibility is by definition less worthy or of regard than of heterosexual couples if they're not afforded equal rights. Point 21, that it's out of order to employ the religious sentiments of some as a guide to the constitutional rights of others, and that there must be mutually respectful coexistence between the secular and the sacred, recognizing the sphere in which each inhabits and not forcing one onto the other sphere, provided there is no prejudice to the fundamental rights of any person in this group. Point 22, the last sentence I'd like to highlight there is the regardless of their strength or sincerity, religious beliefs opposing same-sex couples from marrying cannot, through the medium of state law, be imposed upon the whole of society and in a way that denies the fundamental rights of those negatively affected. They also mention the separate but equal legacy of the apartheid regime, in which the separate law essentially was a repudiation by those in power of the groups subjected to segregation. So they in fact also indicate that even the Civil Union Bill, as qualified without Section 6, is still a separate but equal legislation, but that we're moving towards more inclusive legislation by excluding Section 6. They also indicate later there that separation implies repudiation and connotes a distaste or inferiority and perpetuates a caste-like status that becomes constitutionally invidious. And that legislative remedy is chosen must be as generous and accepting towards same-sex couples as it is to heterosexual couples. This is from the court ruling as well. Section 24, indicating essentially that there's a continued marginalization of same-sex couples despite the Civil Union Bill, and so it hasn't gone far enough. Point 26 on the bottom of page 25 there, the last two sentences, that there's no requirement in Section 6 of a sincere religious objection, and that any measure of establishing whether objection may be motivated purely or in part by prejudice or stigma against LGBTI persons is not possible to determine. And that same-sex unions, as the only reason a civil officer may object, meaning that it endorses the discrimination by state officials on the basis of sexual orientation alone, It's point 27.1. There are a number of their personal experience of what has happened, this free gender organization, that couples are sent away from certain home affairs offices because there's nobody available. Some complained about being asked to return on a different day. Some had to approach different offices. Others were forced to identify each other as husband or wife, or similar insensitive heteronormative concepts. Then 28.2, they've submitted also with this submission a list of marriage officers and of the marriage officers that are willing to conclude same-sex marriages in the DHA. And that these are very limited. The statistics or the summary of these marriage officers is in one of the later submissions, which I'll go into. 28.3, there I'd like to highlight that 421 of the 1,130 marriage officers in the DHA objected to concluding same-sex marriages. 37% of marriage officers objecting to, essentially. However, what this allows the state to do on point 30 there is that officials refuse to offer a service to one group while offering exactly the same service to another group. That this is grounds for prejudice. Section or point 31 there, the second sentence is it's far more difficult for same-sex couples to conclude a marriage than it is for heterosexual couples. In addition to encountering resistance from family, colleagues, and friends, they have to deal with barriers and limitations exposed by the Civil Union Act. Same-sex couples are denied the certainty, excitement, and comfort that heterosexual couples experience in regards to solemnizing marriage. Section point 32 there, the third sentence, same-sex couples can therefore never be sure on the date of their appointment to get married at the DHA offices. They will in fact have to be married, and there's an additional burden that they must overcome in relating to religious exemptions of the marriage officers. And the ability of non-religious marriage officers to obtain solemnizing marriages did not exist before the enactment of the Civil Union Act. So there was no, prior to the introduction of this, there was no discrimination as to which marriage officers, which unions marriage officers could and could not engage in. Point 35 there, they just mentioned a number of different international cases in which countries have taken steps to ensure that civil union bill, civil union act, civil unions of various sorts are implemented uniformly. So they mentioned examples from Australia, Argentina, Brazil, New Zealand, Germany, England and Wales. What I'd like to highlight is from Brazil, where they indicate that a resolution prohibits any public authority from excusing themselves from solemnizing same-sex marriages and unions. And this is binding on the judiciary and employees of registries that solemnize marriage. The Belgium example indicates that basically they have non-discrimination law, which prohibits the grounds for sexual orientation and as a basis for discrimination. Religious marriage officers may be allowed to choose whether or not they will perform same-sex marriages or unions. So we also have this distinction in South Africa. Those who are civil servants provide civil unions, and there are marriage officers who provide religious ceremonies, both of which have legal recognition. So then what I'd like to highlight is point 39 there on the bottom of page 7. Is marriage officers employed and designated by the state in terms of Section 2 of the Marriages Act should perform their services and duties without favor, discrimination, and equality. Point 40, that we should reject deep-seated patterns of past discrimination and continued homophobia. And that 41, that sensitization training of DHA officials is necessary to facilitate positive service delivery for all persons, especially for the LGBTI persons. Moving then on to Okay, submission 5 is essentially in support. Submission 6. What I'd like to highlight in submission 6 is point 5 there, which indicates given the international rise of churches like people like King Davis and the county clerk for the Rowan County in Kentucky and Westboro Church, fearing with South Africa may end without an amendment to the Section 6 of the Civil Union Act. These were, if members will recall, these strong strong homophobic and racist Christian groups in the US. Point 7. This is the Christian in support of civil union, and essentially arguing that we're all created in the image of God, and that it's unacceptable for people working in the state to be given a choice to discriminate based on their beliefs, and that we should be protected against discrimination. Then 9, 10, 8, 7, 8, 9 in support generally. Point 10. Just essentially that same-sex couples have been enduring discrimination for hundreds of years. And this is a young gay man making this submission. And that in the discharge of their duties, they are only acting as representatives of the state. In other words, they are not individuals, but rather a vessel of the state. Point 11, what I'd like to highlight there is bullet 1, that Home Affairs employees are public servants paid by all taxpayers. They're not funded by only taxpayers who share the same perspectives as them. Bullet 3, any employee who refuses to perform their duties should either find alternative employment outside of the department or should change their role. Bullet 4, all law-abiding citizens should be treated equally, irrespective of their beliefs, to prevent denigration to the apartheid state, where the issue is similar to the apartheid state, and that all bigotry is bigotry, irrespective of the kind of bigotry it is. 12, 13, 14, also just generally in support. What I'd like to highlight on submission 15, this is just the individual experience of somebody who was married in the Centurion office, a former member of parliament, indicating that their experience has always been good in the cities, but that this is not the case for LGBTQI couples in more remote aspects of the country, or parts of the country. And particularly experience of women in Khayelitsha who were asked irrelevant, offensive, and discriminatory questions when they tried to apply for civil union. Then 16, perhaps on the top of page 11, the last sentence of the second paragraph there. So why should a state official be allowed to decide who should and who should not be allowed to formally declare their love for one another? And if such official truly does have a deep or moral objection to doing their job, they are fully welcome to resign and seek gainful employment elsewhere. 17, 18, 19, all the same. Going on to 19, this is a kind of a more academic inquiry into international human rights law as it relates to discrimination around the world. The useful aspect of this submission is particular reference to the Universal Declaration of Human Rights and various international law. And in fact, that there's also various court cases relating to same-sex marriage that are referenced in support of the bill, which it's quite interesting to read through. But essentially what they're saying is that the domestic framework in South Africa, in fact, goes further than international instruments, in that it explicitly provides that sexual orientation is prohibited, that sexual orientation is a prohibited ground for discrimination. So we in fact go beyond these international laws in our constitution. So then I'd like to go on to submission 20, we can skip forward to 16, 17, okay. Submission 35 on page 17. This is from COSATU. and that they understand that marriage officers were allowed to opt out of the presiding over same-sex marriages when the Marriages Act was amended to allow same-sex partnerships due to its religious and cultural sensitivity. However, we believe that the society has since evolved and the Act must be amended accordingly to be in line with the Constitution. It is important to note that LGBTQI community frequently experiences serious discrimination in many forms. It is important to note we also continuously seek to combat and further advance and deepen the constitutional rights of South African. The bill will be an important progressive step in this direction. And then the next paragraph, COSATU and its affiliates represent more than 2/3 of public servants, including those officials tasked to preside over marriages. We will work with COSATU and our affiliates to sensitize our members on the need to reflect the values of the Constitution and to educate and prepare them to implement the progressive objectives of the bill once enacted into law. Section 36, what I'd like to highlight is just the last part of that first sentence, that public servants to refuse this service to be delivered to me as a tax-paying citizen of South Africa and the law of our Constitution is discrimination or is unjustifiable. 37, 38, 39, all the same, 40 going on. The next submission I'd like to highlight is on page 20, paragraph 1, 2, 3, 4, where the second sentence there indicates civil society organizations equally raised the concern about Section 6, most notably the Joint Working Group. This is in terms of the draft version of the bill. The Joint Working Group specifically stated that they object to allowing the conscientious objection by public officials based purely on a couple's sexual orientation. They reiterate that Section 6 reinforces discrimination against same-sex relations, which is exactly what the constitutional order ordered the state to address. It was, however, retained in the legislation when it was passed in the National Assembly. So this is in relation to the initial civil union bill. So just indicating that the civil society was against this clause initially. If we can then move to submission 53 on page 22, which is the submission from Lawyers for Human Rights, which also just provides a good overview of the issues in general. And what I'd like to highlight on that submission is on page 24, sorry. Point 5 on that page, 25 on towards the bottom there, in terms of balancing competing rights in an open and democratic society. As they argued in support of, as they used various evidence to support, Section 6 of the Civil Union Act unreasonably limits the equality and dignity rights of same-sex couples by extending the religious rights of officers of the state to more than their justifiable limits. And notwithstanding religious belief, the Constitutional Court has previously held that the right to religious belief, conscience, and practice, the supposed purpose of the limitation, is an insufficient reason to limit the right to equality. And then the next paragraph, that the primacy of the right to equality in our law has been confirmed several times. The primacy of equality over religious freedom. In particular, there was a court in the equality case, case in the Equality Court relating to a guest house which refused to service a same-sex couple, and their argument in terms of having a religious objection was overruled. Essentially, such case law or precedent exists to take equality over religious freedom. So that's a highlight of that submission. Then, if you go into the top of page 27, there's just a highlight of the research that this NGO has done, Gender Justice, which indicates the amount of marriage officers and those who are willing to conduct civil union The main cause for concern there obviously being the Eastern Cape Free State in Mpumalanga, where less than 20% of the Home Affairs officials are in fact willing to conduct civil unions. Then, if we can go to page... Sorry, I'm not meaning to rush this, but I have this highlighted essentially where there are different aspects or unique aspects of the submission. So if you go to page 32 there, on the bottom, the conclusion under point 9 is that first to consider the proposed repeal of section 6 of the bill, which the Helen Susan Foundation endorses. For consistency, one further technical recommendation is made that is submitting the word shall for may in section 4.1 of the Act. So there's a proposal for a technical amendment to the Civil Union Bill to make section 4 in compliance with section 6, because currently section 4 allows for that marriage of officials may conduct the union, whereas now they should be it should say shall, so as to not cause contradiction in the bill. And secondly, just more broadly, they indicate that the part of the issue is the complicated system which governs marriage of both same-sex and opposite-sex couples in South Africa, and that they in fact argue for adoption of a more simplified, more secular, unified marriage bill to kind of cohere all the different current marriages. So you have the customary marriages, civil unions, normal conventional marriages, and also Muslim marriages. So they're advocating for this more simple model for everybody. Then I'd like to go to submission 60. Okay, well, just the last submission there, just another indication from a LGBTI couple indicating that have had terrible experiences trying to get married, and that nobody should be submitted to such humiliation. And then essentially I think everything else, largely overlapping arguments in support of Honorable Carter's submission. 15 minutes.
Thanks, Adam. Thank you very much. Let us firstly appreciate the work done by the content advisor, who has really worked very hard to consolidate all the submissions. We really want to appreciate and thank you very much, Adam. Now, colleagues, we have 2 submissions now. Meaning not 2 we have submissions that we have received from the public, and the position that we took was that we're going to allow for public submission. We'd not agree that we'll take the bill to the public comment, but we wanted public written submissions, and here we are. We have now received that, which is an option, obvious, generally, that the Committee of Parliament will have. So we opted for the written submissions, and the respond is what we have. Can I therefore propose and maybe hear comments from members, and then we'll then deal with the way forward after the comments from members. The parliamentary advisor, I'm not sure that you have had the side of the submissions. You may want to comment on the submissions received so far, but let me first start with members, and then we'll then deal with the way forward. Mamra Pudi?
Yeah, earlier on, Chair, I did indicate that we just received this written submissions from the different stakeholders. I therefore requesting, Chair, if we can go and interrogate, because it's a constitutional matter, and we will take the issue further. Thank you.
Honorable Carter, you have raised your hand. Do you want to make a comment on the submissions? I think the point of Mamraput is clear that we may have to then go deeper into this submission so that we don't just treat them as, submissions, just rush to the amendments without really having to debate each one of them at some point. Is it correct that maybe, let me invite a comment from the parliamentary advisor so far, and then at the same time we can then deal with the process moving forward. Yes, ma'am. For record again, just you'll introduce yourself just for record. Ne? Thanks, ma'am.
Thank you, Chair. Good morning to everyone. My name is Noluthando Mpikashe, and I'm the Parliamentary Legal Advisor. Chair, indeed, I received the submissions, and I had a look at them. They raise very important issues, and by the look of things, there are conflicting rights that are being raised: the right to religion and the right to equality. So, Chair, I would appreciate if the committee could give me time to make a presentation, a thorough presentation, trying to balance the two rights and also present to the committee what the Constitutional Court has said in balancing the two rights. So, Chair, I guess process-wise would need another meeting where I would have to respond to the submissions because most of the issues that are raised are legal and constitutional issues. Thank you, Chair.
Mamu Nkomo, but thank you very much. I think the point is noted. In fact, it then deals with our way forward as to how we want, therefore, to process the submissions. Mamu Nkomo?
Thank you very
You are
much.
noted, Mr. Waters.
Chairperson, thank you.
Yes.
Chairperson, we seem to be in need of, should I put it like well-structured time? Time is not really on our side. So with your guidance, Chair, over the legal advice, which now has been brought up and which we will definitely need that, but even on our own side, how much time would we need? And I must state, Chairperson, to Adam, that having listened to the inputs as well as how he has worked on the matters, I must really thank your content advisor, Chairperson, for the work that he has done. But Chairperson, time-wise, how do we move forth with this process? Thanks.
Okay. No, that's fine, colleagues. Can we agree? My Waters, you can come in before we sort of come to...
Yeah, thanks, Chair. I mean, this issue raises several constitutional matters from both sides. And so I would support the proposal that we do get a presentation from the State Law Advisor regarding that. But I do want to, I don't want us to delay the matter indefinitely. We've got to deal with this matter as quick as possible while doing due diligence to it. So I'm not saying we have to rush through and not apply our minds, but I'm not saying we must delay it indefinitely either. So I would like to support Honourable Nkomo. I'd like to know exactly the timetable we're looking at, so we can all have it in our minds when we're going to be dealing with this matter. Thank you.
No, colleagues, I note your comments, but the honor again, it's on members to go through the submissions and make your own comments. I know legal advice will come in to guide and help us with the balance, but members have a responsibility, therefore, to engage with the submissions. Now, what we'll then propose will be that both the parliamentary legal advisor and the department, Gideon, working on this particular amendment, next week you'll then come and give us the guide on what you have extracted from the submissions that we have received, right? We can highlight the issues that require further engagement, and guided by that balance that we spoke about, that fundamental right that is entrenched in the Constitution on the state may not discriminate on what's called sexual orientation. And that's the bottom line. So we'll give them that work to do, and then they'll come back next week. You'll come back next week because we still have next week again. So this will then be presented again next week. On that note, the issue of the next bill on the IEC, I'm going to propose that we then adjourn here. We'll deal with the rest of the issues when we come back later. But again, I still have to check with the minister availability because we have scheduled the minister exactly at 4:30. I do not want to start with something outside what we have agreed upon with the minister. So I will consult with the minister and find out if it's available for later. Other than that, we'll engage the minister and then we'll finish later at 3 o'clock in the morning with the last item being the item that is before the committee. On that note, colleagues and officials from the department, and let me formally welcome the minister because he came in very quiet when we were busy already with the engagement. You are welcome, Minister, and your delegation has been welcomed already. On that note, the meeting is adjourned until 4:30, same venue here. Thank you very much.